Good day. My name is Penny Roberts. I'm from the Office of the Chief Master in the Department of Justice and Constitutional Development. Today we're going to talk about the administration of deceased estates. An estate refers to all the assets and liabilities which a person owned before they died. So unfortunately, when you die, it doesn't mean that your debts or liabilities also fall away. When you talk about an estate, we talk about those the assets and liabilities which a person owned before they died, and an administration of the estate refers to a process whereby the person that is appointed by the Master of the High Court to administer the estate collects all the assets of the deceased, pays the liabilities, and whatever remains transfer it to the heirs who will inherit from the deceased estate. The Master of the High Court appoints an executor to administer the estate where the total value of the assets in the estate exceed 250,000 rands, and where the total value of the assets in the estate are less than 250,000 rands, the Master of the High Court appoints a master's representative to administer the deceased estate. The law requires that when a person dies and they have left a valid will and or assets, his or her estate must be reported with the Office of the Master of the High Court within 14 days. If the total value of the assets in the estate is 250,000 rands and there is no valid will, the deceased estate can be reported at the magistrate's court in whose jurisdiction the deceased lived in. So basically, the persons who will inherit from the deceased estate will be determined in terms of the valid will if a person died having left one. And if, unfortunately, when a person dies and they didn't leave a valid will, the law will decide and make a determination as to who will inherit from their deceased estate. And in this regard, the rules of interstate succession come into play. And the Master of the High Court will then take the following factors into consideration to make a determination as to who will inherit. For example, whether the deceased was married and whether the marriage was in community of property or out of community of property, with or without the accrual, whether the marriage was in terms of Muslim rights or Hindu rights, whether the marriage was in terms of customary law, whether the deceased was divorced, whether the deceased had children, and whether the deceased is survived by any other relatives, for example, parents, siblings, aunts and uncles. And in this regard, we see a lot of challenges coming into play where a person has died without having left a valid will, where the surviving relatives of the deceased would fight in order to inherit from the deceased estate. So it's very important that you have your wills drafted so that you can have the freedom of testation of choosing who will inherit from your deceased estate as well as to who will actually administer your deceased estate. So be wise, be savvy, make your wills whilst you still can, especially during these uncertain times of COVID-19. People are dying, so it's better that you plan your estate whilst you still can, so that your legacy may live on. Thank you.